The U.S. Supreme Court today held oral arguments on whether to allow the Centers for Medicaid and Medicare Services and Occupational Safety and Health Administration's vaccine mandates to go into effect while appeals are heard in the courts of appeals. While trying to predict how the court will rule based on the oral arguments is difficult, there were some key moments that deserve a deeper dive. Welcome to Advancing Health, a podcast brought to you by the American Hospital Association. I'm Tom Hederle with AHA Communications. We'll be hearing today from Chad Golder, AHA's Deputy General Counsel, talking with Sean Marotta, a partner at Hogan Lovells and AHA Outside Counsel. They'll break down today's oral arguments and what the next steps could be for the CMS and OSHA mandates. Let's get right to it. Chad?
Thank you, Tom, for that introduction, and thanks for joining me today, Sean, and particularly for your informative blog posts as these cases made their way through the courts. Today's arguments lasted for almost 4 hours. They were jam-packed, so there are a lot of places we can begin, but why don't we start with the question that is probably on the top of most listeners' minds. What will the court do here?
What's going to be on the top of most listeners' minds is whether the Center for Medicare and Medicaid Services and Occupational Health and Safety Administration's mandates are going to go into effect. And I think the answer is that the court is most likely to allow it to go into effect. It was clear from the discussion today that the justices see the CMS mandate as different than the other mandates. It's about healthcare workers targeted at vulnerable populations, which are the old and the poor, which because of the social determinants of health are at greater risk from COVID-19. And not only that, but rather than being a direct regulation of healthcare providers, it's really just a restriction on how the federal government spends its money. Much as you might say, I'm only going to spend my money at a store that requires masking, the federal government can say, we're only going to spend our healthcare dollars at healthcare facilities that require their staff to be vaccinated or to obtain an applicable exemption from it. So we discussed in the blog post looking at the median justices, and the median justices seem to think that the CMS mandate is different. Switching over to the OSHA, the Occupational Safety and Health Administration mandate, the court was more skeptical. The court had concerns that the OSHA mandate was not targeted at workplace dangers, but was rather a backdoor way to require most Americans to become vaccinated. And the court seemed to view that that was a power that was reserved to the states or maybe to Congress, but it shouldn't be given to an unelected federal agency. At the same time, however, the court signaled that it may be willing to uphold a more targeted OSHA mandate. For instance, the court suggested through its questions, including the median justices that we've been discussing, that a rule that's targeted at settings where workers are more likely to come into contact with COVID as opposed to just being out in the world might pass muster. So the examples that were brought up included, say, a meatpacking plant where workers sit side by side on the line. By contrast, and also raised was the healthcare facilities. Even those that were arguing against a vaccine mandate in the OSHA context suggested that at hospitals and healthcare facilities, a vaccine mandate may well pass muster.
I was struck by Scott Keller, who was arguing in the OSHA case that he even kind of suggested that either the CMS mandate or a more targeted healthcare mandate might be upheld or might be acceptable, and that his clients wouldn't oppose that. But we'll obviously have to wait and see. I'm glad you focused on the median justices in your answer to my first question. I was going to follow up and ask what specifically about median justices who in your preview blog post you said were Chief Justice Roberts and Justices Kavanaugh and Barrett. What did they say that caught your ear today, particularly as to the CMS case?
What caught my ear from those justices was both what they said and what they didn't say. What they said, for instance, the Chief Justice emphasized that of the 3 federal government vaccine mandates, OSHA, CMS, and federal contractors, he suggested that he saw the CMS mandate as being closest to the regulated parties and closest to the hazards proposed by COVID. one of the concerns that the Chief Justice raised was that these agencies weren't actually addressing things within their regulatory ambit. Rather, they were just saying, we as the government have decided that Americans should be vaccinated. Let's flip through our authorities and see what we can drag out to further that goal. So although the Chief Justice had that, I think, negative view towards the OSHA mandate, at least in its broad scope that it currently is in, when it came to the CMS mandate, he asked the attorney for the government, Deputy Solicitor General Brian Fletcher, wouldn't you agree that of the three mandates, this is the one that is closest to the goals of the federal program and closest to the goals of protecting federal health, which is absolutely right. When it came to Justice Kavanaugh, he too asked whether this is not a perfectly sensible restriction, given that hospitals and healthcare facilities have to agree to any number of conditions to participate in the programs. And this is just one addition on top of it. And I think what's notable is what Justice Kavanaugh didn't say. When he asked some questions of Mr. Fletcher, asking, for instance, how is this different than the OSHA mandate? He got an answer and there was no follow-up. He seemed very satisfied with the answers he was getting to questions from the government and more skeptical when he was getting answers from the state parties. And finally, Justice Barrett, I think, was in the same lines. Whereas in the OSHA mandate case, she had strong reservations about federal overreach. Her questions in the CMS mandate case were much more targeted. They were focused on specific statutory provisions. She was drilling down on the technicalities of the case, not broad concerns about federal administrative power, and that's a good sign for the CMS mandate.
I completely agree, and I'd like to think that it wasn't just because they were 3.5 hours in, but one never knows how long these things go and what that means for the ultimate decision. I will say one thing that struck me in the arguments was that there appeared to be a very fundamental difference among and across certain justices about how even to look at the questions in these cases. It struck me that Justices Kagan and Breyer and Sotomayor, and even to some extent the Chief, and you saw some of this in Justice Thomas's questions, they were taking a hard-nosed look at the facts and realities. The pandemic is a serious threat. There have been more than 800,000 deaths. This is different in kind from anything we've seen since 1918. To them, it was almost like, I know there are legal questions here, but we're living in an unprecedented pandemic, and that has to inform our decision in these other cases. On the other hand, some of the other justices were more acutely focused on legal questions. The so-called major questions doctrine, the non-delegation doctrine, the anti-commandeering doctrine, the general scope of agency authority, all these questions that lawyers like you and I spent a lot of time dealing with, but may not be the core focus of John and Jane Doe out there. Do you agree with me and how this seemed to you? And if you do, what do you make of that divide? And what do you think it means for how these cases might be decided?
I think it comes across in two fundamental differences on the court. One is the problem of line drawing. All these statutes say things like a restriction that's necessary or a grave danger. And one of the things the court was looking at is, well, what do we say when we mean necessary? What do we mean when we say a grave danger? And there was certainly one wing of the court that said, look, whatever grave danger means, COVID is certainly it. When you have nearly 1 million Americans that have died from it and cases increasing every day, we don't need to think too hard about where the line is, because even if there's a closer case out there, this clearly qualifies, and how could anyone think differently? But I think there's another wing of the court that says that, look, in emergencies, that's when we should be most concerned about government overreach. That governments will always take advantage of emergencies to expand their powers. And then when the next thing comes along, they'll rely on the things they did during the emergency to say that this is all precedented and shouldn't be thought differently of. So we saw from the more conservative justices, particularly Justices Gorsuch and Justice Thomas and Justice Alito, taking the view that maybe an emergency is the most perfect time to reassert our limits on our government. And these justices in particular are looking at Congress's role and the state's role, saying that not that nobody should respond to the COVID pandemic, but rather it should be coming from these elected branches. By contrast, on the other side, you had a very strong and forceful support from Justice Kagan of the administrative state, which is democratically accountable to the president, and the president is ultimately democratically accountable to the people. That if people don't like how OSHA and CMS are responding to this pandemic, they'll vote people out, and we'll get other leaders that take a different approach. But this has been a back and forth on the court about the reach of the regulatory state that we've seen for years now. It's just coming out most acutely during the pandemic. But I think that's why we're focused on the median justices, because those three justices, the Chief Justice, Justice Kavanaugh, and Justice Barrett, have really struck a balance between having their reservations about the administrative state, but yet at the same time, understanding that COVID is a grave threat, a strong threat to the public, and things have to be done. And they're going to be the most likely to strike a balance. And particularly in the context of the CMS rule, I think we're going to see that balance come out on the side of upholding a vaccine mandate.
Well, with that prediction, why don't we talk timing a bit, which is also likely on the minds of most listeners. Having heard the argument today, when do you expect the court to act? And since this case only involves issues related to a stay or an injunction, what happens next in these cases?
On the question of timing, it's hard to say because this type of argument is really unprecedented. There's only one other time in the modern era that anybody can find that the court has heard oral argument on a stay application like this. So everyone is naturally guessing. One thing that was brought up, particularly in the OSHA oral arguments, is the fact that compliance deadlines are starting soon. And so perhaps the court may want to act even on a temporary basis before those compliance deadlines go into effect. At the same time, the court took this case to write opinions and to explain its thinking. And so as a result, it's going to take some time to do that. And what the court's going to be doing is striking a balance between wanting to give the public an answer as quickly as possible, but also wanting to write opinions that are persuasive both to their colleagues and to the public that's going to read them. I've been prognosticating that we may see something by the end of the month, certainly before healthcare workers and others have to complete their vaccine series. But at the same time, everybody's guessing. As for the question of what comes next, because this is in a stay posture, the cases would technically return to the courts of appeals to play out on the merits. I think it's easy to say, however, that whatever opinion the Supreme Court comes up with is likely going to control what happens there, because the court's going to opine on not just whether a stay is permissible, but rather whether these mandates were authorized in the first place. Also, as I've discussed on the blog, because these mandates are necessarily time limited, what we hear from the Supreme Court is probably going to determine whether these mandates go into effect at all. What we'll see later, most likely, are final standards that will come out and that will replace these current temporary standards. That could be a place where, for instance, OSHA may tailor its standards to the healthcare and other high-risk contexts. And it may be a place where CMS further explains its reasons for imposing a mandate and gives further guidance to hospitals and other facilities on how to implement the vaccine mandate.
Well, we've covered a lot here today, Sean. Is there anything else that stuck out to you that we haven't discussed? I, for one, noted that Deputy Solicitor General Brian Fletcher referenced the American Hospital Association's recommendation in favor of vaccine policies, which was a nice shout out to the AHA. But what other final thoughts or observations do you have here?
I think two things stick out. The one is, with the exception of Solicitor General of Louisiana, Elizabeth Murrell, everyone, including the challengers, came out strongly in favor of vaccines. They understood that vaccines are the best way to prevent COVID infection, to protect yourselves and your loved ones and your patients. And no one at the podium today was suggesting anything other than everyone who's eligible should receive a vaccine. Second, the justices noted that the entire medical establishment, including the American Hospital Association, is united in favor of getting patients and providers vaccinated. And in fact, it was notable that when normally you have a case of this size, you would normally see the medical community, if it had concerns, come out against it. In fact, the medical community was arrayed in favor of vaccines and always has been. And finally, what I think was notable from Mr. Fletcher was that the emphasis that CMS will continue to have administrative and regulatory and enforcement discretion in how it enforces the CMS mandate. CMS made clear in its guidance to providers when it announced that it would begin enforcing the mandate in the 25 states, the District of Columbia, and the territories where it's not currently judicially enjoined, that providers and hospitals that are working in good faith to secure compliance should not fear enforcement against them as long as they're working strenuously towards getting their staff vaccinated. And the United States repeated that in the Supreme Court today. So what that means is that if you're a hospital, particularly in areas where you're struggling to get vaccine uptake, as long as you're continuing to work in good faith to getting your staff vaccinated, The government is going to take that into account when it conducts enforcement, and that should be a big relief to hospitals and providers.
Sean, I think that's a really important point to end on. It was an important point that Brian Fletcher ended on, but it's particularly important to our members in the hospital community that there will be enforcement discretion, that the government is going to treat this reasonably, and that hospitals, as long as they are acting in good faith, do not have to fear an enforcement. With that in mind, I just want to thank you again for all of the work you've been doing, for talking to me today, your real-time reactions to the arguments in Twitter, and everything else you've done for AHA over these past weeks. I suspect this will not be the last time we'll be calling on you in connection with these very important issues, so we look forward to your continued wisdom in the coming days and weeks and months. So thank you, Sean, and stay tuned.
Thank you so much. And also thank you to all of the AHA members. They're the ones on the front lines that really owe our thanks. We're just doing our best to support them. Thanks so much.